like ये तो बेंच कोई दूसरा है कोर्ट नंबर 3 में कोर्ट नंबर 3 चीफ जस्टिस नहीं बैठे
Yes. Item number 3.
ऑडिबल
Just wait for some time. There was a 19 matter. We'll look at the records. Just wait for some time. Yes, from outside, please making a mention. Okay.
Government request back to the same. With their consent. We have been recently engaged in the matter. Therefore, I pray this matter may come up after 28.
Yes, I am appearing for the appellant in the writ petition of Union of India. We received an intimation with regard to the request for adjournment from the opposite side. What's the date? Yes. Yes. Next date.
Item number 28.
Okay. So when do we fix the matter?
That's for after vacation. First.
Lordship may have it on any Monday in the last week of July.
Then 20th, Your Lordship, if I may. 20th of July.
28th of July.
20.
28th is Tuesday.
20, Lordship.
20.
20th July. 20th July.
Okay.
Grateful means.
Both sides are represented on the prayer made by Mr.
T. Kashyap on behalf of respondents in item number 29.
T. Kashyap, counsel appearing on behalf of the respondents in WA 76 of 2026. Matter stands adjourned today.
Your Lordships are not audible, perhaps.
You're getting the voice now?
Yes, minutes. Deeply obliged.
Okay, can I have your name?
Naresh Kaushik, Senior Advocate, Supreme Court.
Naresh Kaushik, Senior Advocate. You are for the
With Seema Dolo. With MS Seema Dolo.
Apparent appears through video conferencing mode. Mustafa is agreed to by both sides. Lays the matter on 2/07/2026.
Grateful. Great.
I'm hearing for item number 28, Lordship, the tag matter.
28.
There is a connected matter also, means both have been tagged together. Both may be listed on the said date.
28, Miss
D. Mohanto.
D. Mohanto for WBC 5522 of 2020. Okay.
Let's, I have a humble request. I have a humble prayer, let's. On the last date also,
Yes.
on the last date also, let's, the opposite side had sought adjournment and Honorable the Chief Justice was pleased to say that no further adjournment. So on next date, your Lordships may record that there will not be any adjournment. Let's.
Okay.
We have been recently engaged, Your Lordship. We did not get the brief. That is why we are seeking.
It's okay.
I apologize.
But never they make that submission, at least in
Let's, because sometimes on the request.
There's a judgment of this court.
Very well, it's very well.
Where this court
I
has
bow down, it's. I bow down.
That once you appear for someone, you appear with due instructions. Otherwise, you.
I bow down. Let's Lordship may dispense with my let's suppose.
So, no prayer for adjournment shall be considered on the next date of listing. Okay.
Highly obliged, Miss.
Also, with regards to item number 24, Your Lordship. Lordship, this matter relates to that APSC series that Your Lordship has disposed of. Lordship, perhaps I've been informed that not by Her Lordship, Your Lord.
Those APS.
Okay.
In this content,
This is the matter before the end of the bench without one of us. In 24, is it not due for us? I don't think so.
So that is what I've been instructed on her ladyship. Some involvement in that matter. If I'm not wrong. This relates to that series, Your Lordship.
I think
Reinstatement in
No, that is because of the senior counsel engaged. Here, he is not there. Mr. Mishra is not there.
No,
So
no.
there would be no bar, no.
Lordship.
That is because of the notification. We, at times we can't take up matters of concerned counsel or senior counsel.
Then
It
we'll-
is on that account.
First. Made please, your lordship. Lordship, I'd like to mention a writ petition. Yesterday it came up before a single bench, but the matter is supposed to be listed before the division bench, leading to a Tanzanian woman who is waiting deportation. May it come up tomorrow with a similar matter which has been fixed, your lordship.
Okay.
Deeply obliged.
Wait, please, my lord. Prayer seeking requisition in item 35, my lord. I have filed one additional affidavit, my lord, to this. Oblige.
My pleasure, Lordship. Victim mention for item number 4, your lordship. I submitted the adjournment request yesterday of your lordship.
We'll consider, just wait for some time. These are all matters. We have to just check the records and thereafter. Please wait.
May I please, Your Lordship, I wish to mention for item number 8, my senior counsel is out of station, so
It is
matter may be.
2019, please wait. Yes,
May I please, your lordship, I beg to mention item number 17. The matter may come up after vacation. My senior is out of station.
17,
17.
17 application. Also, as a requisite on the pyramid panel counsel for the petitioner, list after the ensuing summer vacation. Okay.
For motion, item 1.
May I please, lordship? Lordship, in this matter, my lord, I am praying for adjournment, my lord. In this matter, my lord, I am praying for adjournment, my lord. The learned counsel, lordship. I am not the counsel, my lord. The learned counsel for the petitioner is out of station due to his father-in-law illness, my lord, and his
Just wait,
father-in-law is
without
critical
looking at the
condition.
record, we are not considering adjournment in all matters.
Notice issue online maybe.
On the stage of argument, it was again reheard.
On instructions from the learned counsel for the petitioner, from say Mubarak, learned counsel for the petitioner is present. So and so appear for the respondents. Pursuant to the order passed earlier, the records of the traveler is received. Requires further examination. Issue notice returnable on so and so without requiring any steps to be taken. List the matter in the admission column on so and so.
First,
Item 2.
Lordship, kindly pass over the matter for the day.
The value of 11.
Your name?
Yes, sir, does on behalf of AP Circle.
The counsel for the learned counsel appearing on behalf of the learned counsel for the petitioner on record. So and so for the respondents. Same order. Pursuant to list in the admission column on so and so.
Item 3.
Allow me to go through the records. Plus the sheet.
Which page is the opinion?
Your file line. File line.
I could not actually cover it finally. So, I mean, really, I will manage it. In the case also will not WS only file will not and nothing more. No evidence and no document.
ये फाइल कोराई नहीं कोराई नहीं सर
Hmm?
तो केस को पूरी लॉक करते हैं इलेक्शन के नहीं अपने दोषे हमने रिकॉर्ड को रास्ते
The extra copy of the order. The opinion.
I have this. I have taken from my understanding, you know, this. I have your file, the statement and also will have copy of the opinion is here.
We'll adjourn it after vacation. On the prayer made by Mr. Hirashi, learned counsel. Say that the matter stands adjourned today. List again in the motion column on due date.
नहीं ना कॉपी वाला कॉपी को घुराई देखो ठीक है आई कैन सी डी
Yes, item 4.
I can call Matilda.
Please, Your Lordship. Also, currently, we are not having any communication with the petitioner, Your Lordship, that's right. So that's why we need some time, Your Lordship.
Please, ma'am.
Okay.
What is represented on the prayer, pursuant to order passed earlier, the records of the travel is received, which requires further consideration. Only issue notice returnable on so and so. Without requiring steps to be taken, that's what, this is the matter in the admission column on so and so. You have the copy of the declaration?
No, Lordship, we don't have.
Say that. Copy of the declaration with conclusions we provided to the download. Standing counsel for the FT and border matters within 2 working days.
Problem.
Give her a copy.
Yes.
12 होगा.
Item 5.
Yes, item 5.
Item 5.
You have a copy of the writ petition?
I have, Lordship.
You're studying the records. There are 2 documents here.
This was.
Something is missing here. It will be flagged. This is a certificate of registration.
Yes, Lordship.
What is the relation? We don't know. Correct. Now, after that, there is a second question. Lekha Sarkar was declared to be in India. Based on that certificate.
I have just gone through the opinion, Lordship.
But this was not discussed.
Yes. It has to go back, Lordship.
Yes, but just check it. That's why I give the cost to you. Mr. Sarkar is not there.
Yes.
So if we send the order, it will be troublesome for the tribunal to again give notice and then bring her. We are done for the timing. We can go through the records. The connect is only this two, but it's not been discussed.
It seems the grandmother was like, declared the Indian Lordship. The opinion says so. And grandmother's name is Kumari Das, Lordship.
She projects her to be grandmother.
Yes.
Now,
She is
based on that,
grandmother of the opposite party.
yes, based on that, you see this Rekha Sarkar got a order the FT. So this will be a based on that, she got a delete in the earlier.
Yes, Lordship.
Now again, she has been proceeded with.
Right, Lordship.
There is no discussion on this too.
19
Page 12 is the in the repetition, page 12.
Annexure 1, Lordship.
No, page 12, paragraph 6. There is no discussion in this too.
And the first opinion is clear, Lordship. The first opinion explains everything.
Yes.
Though the relationship is not, maybe it is there in the records, Lordship. Otherwise, the second opinion should not have been.
Should we call for the earlier opinion records?
Lordship, send it back with this observation, Lordship, because it's already here from,
Mr. Sarkar is not there.
yes.
The problem is that the tribunal will have difficult time in getting her. If Mr. Sarkar is there, we can ask him to make her present on a particular day.
Yes.
So we adjourn the matter.
Or we can, if Lordship passes the order, we can communicate to the SP border there, and earlier also we have done it, Lordship. They inform the petitioner about it and then she appears. Since it's already here for a very long time now.
Yes. 2019.
She was 45 years and 19, Lordship. Now she must be in about 55, 56.
None the reason call for the none the reason call for the petitioner. However, so and so for the respondents are present. Next, I filed this petition under Article 226 of the Constitution of India. Petitioner, namely so and so, has assailed the opinion dated page 10, dated 11/6/2019, passed by so and so in FT case number so and so, by which the petitioner, namely so and so, is declared to be a foreigner post 25/3/1971 stream. Next one. In view of the order which is proposed to be passed, the court does not. There is no requirement of burdening this order with pleadings and evidence on record. It would suffice to mention that that in the proceedings, the petitioner had exhibited a citizenship registration certificate of one Sukumari Das, as exhibit one, projecting her to be the grandmother of the petitioner. Based on the said citizenship registration certificate, the learned member, foreigners tribunal Bhimaji, by an opinion dated 10/6/2014, passed in case number FT/DMJ -705/2007, arising out of district DIST, full stop, IM within bracket D, bracket close T, case number 81/98. Referred to the said certificate of registration of Sukumari Das, wife of Mohendra, Mohendra, Mohendra Kumar Das, AR, instead of Das, within bracket exhibit 3, and declared the proceeding therein, namely Rekha Sarkar, to be a citizen of India by birth and not a foreigner. The petitioner projects herself to be the daughter of Anat Das, ANAT, Anat Das, and to show her link with her projected father, she has exhibited a certificate by All Assam Other Backward Classes Apostrophe Association, issued on 29/6/2005. And the voter identity card of Anat Das, showing father's name as Mohinder. The learned tribunal, though referred to exhibit 1 to exhibit 7, exhibited by the petitioner, there was no discussion on the citizenship registration certificate within bracket exhibit 1, opinion passed in FT case number 705/2007 within bracket exhibit 3. Therefore, comma, in view of the fact that if a citizenship registration certificate is produced from a, the person would be, the person concerned in whose name the citizenship registration certificate is issued would be a citizen of India under section 5 within bracket 1 within bracket A and 5 within bracket 1 within bracket small b of the Citizenship Act. Moreover, comma, if the opinion which is opinion in FT case number 705 of 2007 within bracket exhibit 3, comma, if it is in respect of the petitioner, comma, principle of certificate of reply. According to comma, what is of the considered thing that the non-consideration and the discussion on the exhibit 1 and exhibit 1, exhibit 3 and exhibit and other exhibits vitiated the impugn opinion dated 11/6/2019. Accordingly, comma, the court has no hesitation to remand the matter to set aside the impugn opinion dated 11/6/2019 and remanding the matter back to the said learned tribunal for a fresh appreciation in accordance with law. In the next, in the impugn opinion, it has been stated that it has been mentioned that exhibit 7 was a photocopy. Accordingly, the petitioner will be entitled to an opportunity to produce the original of exhibit 7 for inspection before the court. Next part. The on receipt of the records of the non-traveling shall issue notice to the respondent for the appearance before the said learned tribunal. By issuing process through the border police attached to the superintendent of police borders Himaji. Next part. As the petitioner is unrepresented today, comma, the court is inclined to provide that the police should be police personnel effecting service of notice shall make an endeavor to place on and effect service on the petitioner. Next now. The registry shall send back the records of the tribunal along with a copy of the order to be made a part of the records. Next paragraph. The learned standing counsel for the FT and border matters is also to transmit a download copy to the superintendent of police border. Giving the order to the notice of the said authority. Which is nice. allowed on terms and litigated over, right? Setting aside the influence opinion and by remanding the matter back to the said learned tribunal for fresh opinion.
Lordship has fixed a date for her appearance.
No, because the tribunal will issue a notice.
Yes.
She's not there today. That's why I said that if we can pass an order in his presence, then perhaps he could have introduced it.
Lordship, can I have this order copy today because tomorrow is the last date?
Thank you.
So we can communicate it when the court is open, Lordship.
Item 6.
This Sarkar is normally here, but he is unwell.
I'm ready. Yes, exactly.
That's why. Oh, no, this is AD Sarkar.
No, H is a
No, this is Sarkar. This is Sarkar.
I think notice has also not been issued, Lordship. Notice has also not been issued. I
Yes.
guess. Can we make a case in it?
How the respondents are represented pursuant to order passed earlier, the records of the travel is received, which requires examination. Issue notice returnable on so without requiring any steps to be taken. List the matter in the admission column on so. Here the appreciation was wrong, but the result is right.
Item 7.
Mr. Sikdar, unless you want to argue, we place it for admission some other day.
My lord, I'm not keeping well, yet I have,
No, you are still not responding to the query. Our query is that unless you want to argue the matter, can we
Well,
fix it for admission some other day?
my lord, any other
Okay.
day.
Heard Mr. A.R. Sikdar and the senior counsel assisted by Mr. S.I. Taluk. S.I. Taluk. S.I. Taluk, done counsel for the department, and for the respondents. Pursuant to the order passed today, the department examiner is received. Which requires examination. Issue notice returnable on so and so. You need copies? No, you have it.
We have a copy.
Hmm?
We have a copy.
You have, okay. Without requiring any steps to be taken, list in the admission column on so and so. 12th of August.
Develop letters.
Item 8.
But Mr. Sikdar, while you said that you were unwell, you were putting your hand towards your
Well,
stomach. So
Well,
is it
nobody is
over-
appearing, therefore I feel that I should do, if I'm not
Okay,
keeping well.
I thought you're, without involving others, you had a
My-
party yesterday. Next.
Item 8.
May I please take Lordship? Lordship, my senior is out of the station. Say for a Durgan.
Has not been issued to this item also.
Hmm?
Notice has not been issued.
No, that's why we are just looking at the records. Both sides are represented. Pursuant to order passed today, the records of the tribunal is received, which requires examination. Issue notice, returnable on so and so. You have copies?
You have that.
Without requiring any steps to be taken, listed in the admission column on so and so.
12th of August.
Item 9.
May I please your lordships?
Yes.
Lordship, what happened in this, may I, your lordship?
Yes.
The petitioner is an Indian citizen by birth, your lordship. I have annexed the documents of voter list of 1970, 1977, 1984, 1989, 1993, 2005, 2010, 2015, your lordship. And his grandparents, his grandparents and parents, their names have been enlisted in the voter list, your lordship. He was marked as the voter, and then he was called from the foreign tribunal, Kamrup Rural, number 1, to appear before the honorable tribunal member, and he appeared on 20 February 2019, your lordship. And he was given 7 days time to file his WSN documents, your lordship. It was on 27 to February 2019. Then he seeked one more date. It was on 8th February 2019. There his prayer was rejected, and the judgment was passed on 12th March 2019. That means, your lordship, he was given only 20 days to file his innocence, to prove that he is Indian citizen, from the date of his appearance to the date of judgment, your lordship. So I just want to, I just pray for one chance, your lordship, to remand back this, and a chance may be given to me so that I can file my written statement and documents to prove that I am an Indian citizen, your lordship. That is my case, your lordship. So to the point, lordship, it was a pleasure hearing you. You're so to the point.
Yes.
Okay, and that's
Yes.
exactly what we wish like it happens.
Let me speak that's now for the petitioner and so for the respondents. Next, by filing this petition under Article 226 of the Constitution of India, the petitioner has essayed the opinion dated 12/3, 2019, passed by so-and-so, in so-and-so, page 44. Thereby declaring the petitioner to be a foreigner of post 25/3/1971. The petitioner was served with a notice to appear in the proceedings with the date of appearance on 2/02/2019. From the prayer for adjournment, the matter was adjourned to 27/2/2019. Thereafter, the petitioner sought for further adjournment on 27/2/2019, and the case was fixed on 8/3/2019. From the prayer for adjournment, the matter was again adjourned to on the prayer for adjournment, the same was rejected, and the matter was fixed on 12/3/2019 for passing necessary orders. And accordingly, the imperial opinion declaring the petitioner to be a foreigner was passed on 12/3/2019. Accordingly, the learned counsel to the petitioner placed for one opportunity to the petitioner to contest the proceedings. Next. The learned standing counsel for the FT and border matters has opposed the prayer on the ground that the rejection of prayer for adjournment was in accordance with the provisions contained in Order 3 of the foreigners within bracket tribunals, bracket was order, 1964. Next paragraph. Consider the submissions. In this case, the notice of appearance was fixed on 20/2/2019 and the ex parte opinion was passed on 8/3/2019. Under order 3 within bracket 14 of the foreigners within bracket tribunals was order, 1964, it is desirable that the opinion that the reference be answered within a period of 60 days from the date of service of notice. Under these circumstances, the court is of the considered opinion that the petitioner should give that as the opinion were passed within 20 days from the date of first appearance, court is of the considered opinion that petitioner deserves one more opportunity to contest the proceedings. Accordingly, the court is inclined to set aside the opinion dated 12/3/2019, passed by page 44, passed by Susan. Next, the matter is remanded back to the learned member from Foreigners Tribunal, Kamrup, number 1 at Amingao. No, this is Gauhati. Kamrup at Gauhati. For a fresh opinion, after giving an opportunity to the petitioner to continue to file evidence, file his written statement of defense and produce evidence. Next paragraph. The petitioner is, who is duly represented by his learned counsel, is directed to appear before the said learned tribunal within the outer time limit of 30/7/2026, and on the said date, along with the certified copy of this order, shall also file his written statement of defense along with the documents on which he intends to rely upon it. So the petitioner shall also take requisite steps, if so advised, for securing presence of the witnesses or to call for the records. From the date of first appearance, the learned tribunal shall make an endeavor to dispose of the application within the time as prescribed under into 17. Within the time prescribed under Ms. Verma, how do you now call it? Normally we are trained to say that when it is an order, we say order one, order two, or something like that. But in this book, they have referred to this. Uh, this publisher has referred to this as para. So what do you actually call this?
Referring to which one, Lordship?
No, in the foreigners tribunal's orders, the, what do you call the orders? It is order or para or clause, what do you actually call it? Hmm? It's order three. But in this book, they have this. Now they have this publisher has referred to it as paras. That's why we are asking. At the top, you will find right side. Top, left. Yes.
In the order itself, para is mentioned. See here, order three, rule, whatever.
It's a paragraph.
It's a paragraph.
No, but in this, because now it is this, here you will find P, subparagraph, sorry, two, subparagraph. So if it is paragraph,
So it is para.
should be
Let's
paragraph.
suppose para only. In the Immigration and Foreigners Order 25. See order three, page 41. It is referred to as subpara. So then if one becomes subpara, so three will become para.
Something new has come.
Para P, within bracket 14 of the foreigners, the
Immigration Foreigners Order 2020.
under the immigration and foreigners order of 2025. The petitioner sends, the registry shall send back the tribunal's records expeditiously. The petitioner stands allowed with an order of demand as indicated above. There shall be no order as to cost.
Deeply obliged, Your Lordship.
Yes, item 10.
Yes.
Opinion at page
Opinion at page, not 21 or
21.
21 or 21. 20.
That's the model. Both as the represented. Pursuant to order passed earlier, the records of the travel is received, requires examination. The notice returnable on so and so without requiring any steps to be taken. List in the admission column on so and so. Ms. Verma, you have a copy of the petition? Wherever you don't have, please indicate. Wherever you don't have, please indicate. Will
Obliged.
Of August.
Item 11.
Maybe in this case, notice was not issued. Which page is the opinion? 51, my lord. 51. Okay, same order here. What says the represented? Pursuant to order passed earlier, the records of the traveler is received, which requires examination. Issue notice returnable on so and so. Next in the admission column on so and so.
Item 12.
Page 24, annexure 1 is the opinion.
Page number
24.
What is the name of your father? Mujibur Rahman Rashid. Page 52, 1966 voter list.
They'll be controlled much after the control. Or maybe after the control. Exhibit E, only say it. You're not going to, it will say. Then you win.
Ms. Verma, this matter also calls for a remand.
This one, Lordship.
You just show you the records, we'll take it up some other day because you'll have to make your submissions on this. This perhaps happens because lawyers don't know how to exhibit the document. Now, this, somewhere in the front, first part. No, not so, so high. 10 pages down, 10 pages, about 10 pages down. The exhibited documents are marked.
Yes, Lordship, after page 10.
Yes. You've seen that?
Yes.
The documents marked as exhibits. It has the seal and signature, photocopies. You've seen that? Now, there is exhibit. C, which is the Jamabandi. Two or three pages of. Yes. You've seen exhibit 3.
Yes, Lordship.
You see the top, Mrs. Sharma, please read it for her. You see, in the first it says 1956 to 65. Correct? And first entry is Mujibur Rahman. Correct? Yes. So therefore, this, in this Jamabandi, the name of the father of the petitioner appears in 58 to 65.
Yes.
Now, after that, you will find exhibit E, after one page, sale deed.
Yes.
Yes, this sale deed is of 76.
Mujibur Rahman.
Correct, by Mujibur Rahman. Therefore, the father is there from 65 to 76, he is there. Now, come to next page. You will find the opinion.
Yes, Lordship.
Yes, this opinion again refers to that Jamabandi of Mujibur Rahman. Next page.
Sakina Khatun's
Sakina.
opinion. Yes, Lordship.
Refers to the land documents of that Mujibur Rahman. Exhibit 3 or something.
Yes.
Correct? And
1970, her
declared
father
to be in India.
yes.
Now you will come here in the opinion at page 27.
Yes, Lordship.
Now this second last paragraph. Exhibit
Proceedings submitted exhibit C.
C.
Yes.
And it was rejected because up to date land revenue is not there. Correct. Now please come to exhibit next page. DW4 Sakina Khatun came and gave that evidence. And her evidence was discarded because she does not know when his plan shifted to Bangalipara.
Yes.
That perhaps is not sustainable. And then next page, page 29,
Yes, Lordship.
exhibit G, judgment and ordinance measure, this cannot establish that proceedings in Indian. But that she's the sister is not disbelieved.
But the document is.
And exhibit E, that registered sale deeds were debriefed because it was 70, post 71. So this post 71 is a mere expenditure. They are referring to the continuous stay and then says that this is the land procured here and there.
We just need to see if in the written statement, Fazila Khatun has stated about her sister and the, thing, the
So that's why we are just
Property
directing to you, you go
of the
through it,
land lordship.
go through it.
We'll do that lordship.
Even if it is not there, she has come and deposed.
But then lordship, all of a sudden coming and deposes, we have told you
But
that.
it has been declared to be a,
No, in the
Yes.
written statement, it was there. Sakina Khatun thing was written.
It is in the WS?
Yes.
So
It's
that
there in the-
establishes, because if this story is, the continuity is there, lordship, then we have nothing to disbelieve.
The sister's name is Sakina Khatun, but in learner travel was declared her as Indian.
So it establishes lordship. If lordship desires to pass, we can fix it up on the reopening lordship. Lordship may observe these things, so we will, the order
just
will.
noted because we,
It was nothing.
at times,
No, but it's, half of the work is done now, lordship.
yes, that's why, but I won't remember.
I'll make a note of it, lordship.
This is item 12. Both sides are duly represented. Pursuant to the order passed earlier, the record of the tribunal is received, which requires examination. Issue notice returnable on so and so. List in the admission column on so and so.
Item 13.
In this matter, notice was not issued. The notice was not issued, interim.
Where is that page?
Page number 75. The record was called.
Documents are of Nasiruddin Ali. Same person, Nasir Ali. No. Yes. This number is also same. Lordship, there are two judgments. One is 25-6, one is 6-5. But, and even the members are different, Lordship.
Good.
One is 19. We'll have to look into it, Lordship. Yes, yes, I
We
can.
give you the custody of these records.
But Lordship will make an observation, only then we can send it for,
Okay. Pass.
some observation is required, Lordship. It is passed for,
You're aware of the two opinions? No.
Two opinion, one is ex parte that was set aside by this honorable court. Thereafter, this
and
one
the
is.
synopsis is written, Lordship.
This was allowed. It's not ex parte. This is allowed.
Yes.
Okay. This was set aside.
Yes, set aside. Yes, page number 14, I have annexed the order also.
Number 14.
Yes.
Okay.
1.
That means already 2 rounds of litigations have been over, Lordship.
Okay, then we don't have to need to make the other inquiry. Okay, yes, same. Okay. Okay, then that inquiry need not be made.
And merit, Lordship may take it up.
Says that represented. Pursuant to the order passed earlier, the records of the tribunal is received, of which requires examination. Issue notice, returnable on so and so, listing the admission column on so and so.
Item 14.
Notice issue is, notice issue, Anna. Okay, so notice.
The opinion.
Lordship, in this case, final order is at page 30.
Lordship, whether notice has been issued, I'm not sure.
No, not issue.
Litigation without notice, so court order.
Lordship, final order is at page 30.
Jahid Ali?
Jahid Ali is my father. Actually, what happened in this case, probably due to improper legal advice, certain only limited documents were filed before the time. Got it?
Three numbers of exhibit.
Three number of documents were exhibited, and others, though he was having the documents, that was not. In 1971,
We sitting here, we have observed that it is very difficult on our part to concur with your submission that he was given improper legal advice.
probably not, because he has given probably, that is why I have said it probably, because the WS that was filed, though he was having the documents, those were not exhibited. Now it will come to his part that there was a mistake on his part, because he is a illiterate man and 71 years at that point of time. So he may get, and if he got an opportunity to produce this document, tribunal may decide that. Because in the 1971 voter list, the certified copy he has submitted, only his father's name and mother's name was there. But the other copy, he was having a copy where his name was also there in 1971.
Did not,
71 years of
he
age.
did not have the copy. He got this copy after the opening.
Subsequently, he has procured the certified copies.
Therefore, he did not have those documents. See, both sides are represented. Pursuant to the order passed earlier, the records of the tribunal is received, which requires further examination. Issue notice, returnable also and so. List in the admission column also and so.
Much.
In that which page?
In order, page 70. Operative portion lawsuits may kindly see page 71. Second para. The opposite party deposed that her father is
Just a moment. This is a written statement.
page 56.
Did the headmaster of the school come and depose?
No.
Okay, we take it up on the admission time here, issue a notice. Both sides are represented. Pursuant to order passed earlier, the records of the tribunal is received, which requires examination. Issue notice returnable on so and so. List in the admission column on so and so.
Publish.
Item 16.
That should be opinion at page 12.
I've seen that.
Mm,
None appears on call for the petitioner. All the respondents are represented. For example, justice, the matter stands adjourned today. Next. Pursuant to order passed earlier, the records of the tribunal is received, which requires examination. Next petition notice returnable on so and so. List in the admission column on so and so. We are passing an order. Please see page 17.
This
1-7 of the petition. There also the petitioner is absent. This opinion is firstly written. Is still continuing? No.
Item 18 for motion.
not been served for you. But you have not given us a copy. Not served us a copy. If it is there, sir. Check the record. Yes, sir.
For now, I can hand over.
Yeah, thank you. This is, we represent state of Assam. Police,
Yes, yes, ma'am.
but will not serve this.
Oh, it will even not move.
Party opinion,
Lordship,
which page?
Lordship at page 32.
What is wrong in this order?
Okay, it was an ex parte order, and Lordship, in this matter, we have not, we have no knowledge about the proceeding, Lordship. In fact, the
But notice was served.
Lordship, in the para 3 and 4, the order, it was made, Lordship.
We have seen that, that's why we are saying.
Yes,
was
in the
every-
para.
Notice was issued and served. We didn't receive. At the wall of Kailipara Bazaar,
Lordship,
Where she last.
of that
resided.
place where the opposite party last resided.
yes. It was hanged on wall, Lordship, and it was delivered to the council.
That was the that is the
Not-
procedure.
not
prescribed.
2020 order lordship. I think I'm today has been executed.
You have not annexed the service report.
Lordship,
You have not annexed the the service report.
Sorry for the records because we stated that they had this certificate, refugee certificate.
Yes, last page is the refugee certificate.
Yes, lordship.
my brother was also.
Well,
No,
page,
page 35.
You call for the records.
yes, lordship.
Your name?
BP Sharma.
Well, Mr. D.P. Sharma, and counsel for the petitioner and so for the respondents. Right.
Okay, fine. Okay, lordship. Lordship, I think we have to amend this clause title because we've not made the deputy commissioner also a party. And RC is also not a party, but RC we can leave, but BC will leave lordship. District commissioner of a party. No, but you have to make district commissioner. You DC, that's your source. RC, BC. Yes. Sufficient time has been granted, lordship. The order sheet is at page 29. You were represented earlier also. Look at the benefit, do you remove locally?
Yes, well, please come to page 24.
I'm at page 24 only, Lordship.
Yes.
He's his
In
name appears here
24,
also.
it appears that the writ petition was filed
Yes,
for devoter.
the voter.
And this court passed an order that
Yes,
necessary
Lord.
orders by the election commission would be passed within 2 weeks.
Yes.
And this petition was disposed of.
And the brother has names, D has been removed. The first petitioner.
Yes. So whatever be, but we are, that's not the point we are trying to urge. This page 24, the address given is house number 161. In the application page 4, this is the same house.
Yes.
So therefore, it's not changed the address. And the tribunal passed an ex parte order after issuing notice on 2020. That means he is the same person who has come to court earlier,
Yes, Lordship.
and he has disclosed his address earlier point of time at the same address.
Notice was also served to the same address, I.
No, it was sent to Haripara Bazaar. Yes. Haripara
Yes,
Bazaar,
yes.
the location would be same, but
It was posted where the petitioner last resided. That is what the opinion states, Lordship. Notice returned after service and cases good for so and so. But I fail to understand when he already has a order and election commission was supposed to take a decision within 2 weeks. His brother's name got cleared. What about him?
he missed out somehow.
Where did he find his brother was cleared for?
He just
Lordship,
paid-
what to know about the status on
connected with
Lordship,
Page?
page 34.
34.
Annex D if is regard to the petitioner and E with the
Brother.
brother.
He is the brother.
This was communicated in 2025.
Lordship.
Yes. Complete lack of communication, Lordship, from the matter to the High Court to the Election Commission. Complete lack of communication, otherwise this is a 2006 order of the High Court. And 25, if they are communicating, but there is no D. And it's the same family, two brothers, same address.
That's fine. Instead of calling for the record, we will send it back, it's better.
Lordship may pass directions.
Because of this, page 34,
Yes, it is their document, it's the same person. Nothing.
in the meantime, the brother has been declared to be a foreigner.
Yes. Yes. And that is in 19. He was declared foreign in 19. And the letter comes in 25, Lordship.
Right.
The complete chain is missing from 2006 up to 25, Lordship.
Actually, he was
Instead
small
of calling
vegetable
for the record, we send it back. Let the family decide.
And Lordship may make this observation that whatever he is annexed now, the observations can be there.
This was for the respondents.
Had he appeared and given the High Court order, I think everything would have been solved. Because it never appeared only, Lordship.
No, but if it is done for one, that means the High Court order is going for both of them.
Both of them, both are petitioners before this court.
What is- Petitioner has said the ex parte opinion letter 7/1/2020, page 32, passed by so and so in FT case number so and so, IMDT case number so and so by which the petitioner was declared to be a foreigner post 24/3/1971 stream. It is 24/3/19. As per the said opinion, comma, the notice of the tribunal was served by affixing a copy of the notice on the wall of Kailipara Bazaar of that place where the petitioner last resided. And accordingly, the learned tribunal, upon accepting the service report, passed the ex parte opinion as the petitioner did not appear and contest the proceedings. Next paragraph. The learned standing counsel for the FT and border matters has opposed the prayer made in the writ petition on the ground that as notice was duly served, no case was made out for interference with the inferior opinion. Next paragraph. In this writ petition, the petitioner has annexed photocopy of an order dated 23/1/2006, passed in WPC 8847 of 2005, purportedly selling the marking of his name as D voter, of their news as D voter. According to the election commissioner, the election commissioner from Assam was directed to take necessary steps for disposal of the application of the head petitioners within 2 weeks. Next one. The petitioner has produced a photocopy of letter under memo number DCP within bracket B, page 34. So dated 21/7/2025. From the Deputy Commissioner of Police within bracket border, Gauhati, to the election officer from a Kamrup Metropolitan Election District, intimating that the petitioner was declared to be a foreigner by opinion dated 7/1/2020. And thereafter, the so the petitioner has also annexed another communication numbers also page 35, which is in respect of the first petitioner in WPC. Okay, first.
Double 847, Lordship.
No, I noticed suddenly you have a certified copy of this order.
Lordship.
Why have you not annexed the entire copy? This shows the certified copy. First petitioner in WBC 8847 of 2005. Wherein it has been mentioned that there is no any D voter public FT case pending against the petitioner number 1. So you have saved 1 rupee in photocopying.
First page.
Do you think you have done good?
maybe it's the first time they're filing this matter. Lot of, small things are missing.
The petitioner is also annexed a copy of certificate of registration. Issued on 8/12. Where do you get this date?
Lordship,
20, this, where do you get the date of 17/3/1950?
Lordship, where is, it's not written.
How do you get it?
It's for basically information. no?
Do you have the original of this page 37?
They have a legible copy, but not original. This is a photocopy, Lordship.
Get the date of 17/3/1950.
It was mistaken. It should have been something clear.
There's some mistake, Lordship, with my friends.
Otherwise, it is mentioned there of 1950.
It's written 50,
Yes. December 12th.
8/12. But the other two letters, Lordship, I am not able to, there's a overwriting in it.
This is overwriting.
I feel there's a overwriting there.
There is a date there, 8/12/1954 perhaps. But then again, there is another place, see on the left side bottom, date and place of issue. Perhaps something was written there. Not
But
legible.
It's not legible at all. It's from Tripura.
And 54 is overwritten, 54 or what?
Yes,
Yes, 8/12.
it's overwritten.
It's overrated question is because earlier it wrote in Bengali.
Sorry,
Get the original of this because here again 8/12 something is overwritten.
sorry.
Earlier it was in Bengali. Thereafter he made it, corrected it to English.
So why did you do it?
So this is
No, no,
overwriting.
we have no doubt. It was done from the office itself.
Okay.
This is overwriting on that.
My friends are saying that earlier it was written in Bengali and
Thereafter
again
they have
got it corrected to next page, Lordship. No, below Lordship will see in PGPA 1856, below date and place of issue.
This is a date.
Yeah, and there's something
4856
of something of 1856,
No, this is something else.
something else.
This is, you know, what is this?
No, yeah,
This is when the government press gives it to someone, that means 2 lakh copies was printed on 1/5/56.
okay.
So these are copies which are printed and the printer, they have given TGPA. So whatever is the, whatever is the name, they give the printer and then you will find it in your matric certificate mark sheets.
Mm,
There you will get a small printer because
Number.
under the Press and Press Registration Act, there is a requirement to have the name of number of the printer given in every printed page. You know, because I have a special knowledge for this, because my father had a business establishment where it printed the envelopes, though the shop envelopes where goods are packed. So we had those printers name printed and our own initials so that those are not duplicated. So when I was in a small tender age of 8, 9 years, I was informed by my father about this law. That was a very unique packaging. So you get the original of this document. Because this is overwriting there. Overwritings we are not inclined to accept.
Gotcha.
You can produce it tomorrow?
Can you bring it tomorrow?
No.
No, no problem.
It will take some time.
Then it
After
goes
vacation also.
After vacation.
And
Can you get us information, Ms. Katagi, about this, in the, about the inquiry which this court ordered? By the next date, you can get the information. Page 24. Correct? 26 is the part. Get the information in the meantime, what has happened.
because in the case of his brother, there is a report from the DCP that no case is pending. Whereas during the inquiry made by the election commission, this had come. So what happened to him? Is the petition? The petitioner might have, there is a case against him, and so there is again an opinion later. So what happened to the representation?
Opinion dated funds has been issued. Issue notice returnable on 18/7/2026. The copies of the litigation be served on the London CGC State and Department Council in course of the day. Next para. In the meantime, the London Standing Council for the European, the Election Council of India shall obtain information of the inquiry, if any, made pursuant to order dated 23/1/2006, passed by this court in WBC 8847/2005, within bracket, Annexure A. As it appears to be an overwriting in document in Annexure F. The petitioner is directed to produce the original certificate of registration within bracket Annexure F, available at page 37 of the writ petition. We give him an interim bail till then. The prayer for bail is opposed by the London Standing Council for the FT and Border Matters. on the ground that the ex parte opinion was passed on 7/1/2020 after due service of notice. The receipt made in view of the nature of defense taken, the court is inclined to 10 days time to the petitioner to take bail of rupees 5,000 to the satisfaction of Deputy Commissioner of Police within bracket order, Kamlo Metro, Gauhati. This conference. This item.
14/8.
14/8, no? So copy দিবা election commission को দিবা আমাকে দিবা
This one is my copy. I will give you another copy.
Hey to.
No, that one.
but I have
You have written.
yes.
Even I will put your. Okay.
No problem.
Thank you.
Okay.
Oh,
what was it?
Zero.
Hmm?
Zero.
হয় নেকি? Okay.
মই চাৰে কৈছে environment থাকিব বোলে।
ভাগিব?
আপোনাৰ অসুবিধা থাকিব।
Item 19.
Yes, Mr. Khan. Opinion page.
Forty-seven.
47.
This is the judgment. 10%.
Yes, Mr. Payang. Petition notice call for both the records and then
But yes, both the record may be called for, but I have seen by the police references of same number. That is.
no. In this case, without any reason, it has been dropped only on
Yes.
the basis of inquiry report.
Yes, ma'am. Okay.
This otherwise is not sustainable.
Yes, ma'am.
But this order was never in the challenge.
So both the record may be called for.
That is not applicable. Without any evidence, the tension is so emphatic, the better.
Yes, 98. So, same document, 98. Over page 98, your lordship, page 98. On the basis of same document, said such evidence, the brother of the petitioner, Hitler India, for 11 days of this order. Page 90,
90,
98. 98,
98.
next up page. One brother. Krishna and so and so for the respondents. Finding this regulation in Article 226 of the Constitution of India, opinion at page 98. Page 85. Huh? 85 is the opinion. 85. 98 is one, we have a brother.
85.
opinion at page 85, dated 9/2/2026, passed by so and so in case number so and so, police reference number so and so, by which the petitioner was directed to the foreigner for control of possible speed. Notice returnable in full, extra copies. Call for the following 3 records. Number 1. For 47. 40? 47. 47, 85 and 98. Page 47. Case number so and so, reference number so and so, from the court of so and so. No, from the so and so tribunal. Second is page 85. Third is page 98. All 3 are from the same tribunal, huh? The right 1 to 3 from these tribunals. Therefore, bail is opposed by the standing counsel for the OT and border matters, considering the projection that on an earlier occasion, by opinion dated 12/9/2013, the same learned tribunal had by an opinion dated 12/9/2013 passed in FT 5313/DBB/11 had declared the petitioner to be a foreigner, 10 days time to take bail of rupees 5,000 to the extent to the satisfaction of Superintendent of Police Border Dhubri. List on so the list after 4 weeks. Okay.
Item 20.
Page 30. Page 30. Mr. D.K. Agarwal, and counsel for the petitioner. Opinion and so and so for the respondent. Opinion dated page 30, 10/11/2023, passed by so and so in case number so and so, corresponding to D case number so and so, by which the petitioner was declared to be a foreigner of post 1971 stream. Notice returnable on so and so. Extra copies within 2 days, called for the records. The prayer for bail shall be considered on receipt of the tribunal's records. Next para, in the meantime, if the petitioner, namely Ajufa Khatun, is apprehended, she shall not be deported out of the country without order of the court. So the petitioner shall produce a certified, cause production of a certified copy of the order for the Superintendent of Police Border, Mogan, to bring the order to the notice of the said authority. List on so and so. Can it be the last week, 27th of August, 28th of August?
Item 21.
May please note, contested case my lord, and opinion is case 105 my lord. Opinion dated 18/8/2025. Mr. H.R. Ahmed, and counsel for the petitioner, and so for the respondents. page 105, dated 18/8/2025, passed by so-and-so in case number so-and-so, D case number so-and-so, by which the petitioner was declared to be a foreigner post 25/3/1971. Notice returnable within 4 weeks. Extra copies have been produced, called for the records. The period for bail is opposed by the witness stand for the actual notice. Then this time take bail rupees 5,000 to the satisfaction of Superintendent of Police Border, Hooghly. List of reports.
Supplementary item 35 for motion.
Sometime Lordship, D not will appear, Lordship.
Upgraded item 27 IA Civil 2116/26.
Earlier, interim bail was granted, but getting 10 days time to appear before the SP Corpora. But the case record has been transferred to SP Baksha, the inform. And SP Baksha was not met party in the petition.
Okay.
Decided.
With Mr. H. Ahmed, learned counsel for the petitioner and for the applicant and so-and-so for the respondents. Next. The applicant is the petitioner in connected WPC 1481 of 2026. This code by, next paragraph, this code by order dated 1/2/2026. 1/6.
On to 2026.
Your cost title is 1/2, the order it is 1/6. What is right?
1/6. What's the rule 1/4?
1/6/2026. Passed in WBC 1481 of 2026. While issuing notice allowed the prayer for bail in respect of the applicant, granting 10 days time from the date of the order for the petition, for the applicant to appear before the Superintendent of Police Border, Borpeta, and take bail. Stop. Next, it is submitted that on approaching the said authority, the applicant came to know that the records were transferred to the Superintendent of Police Border, Baksa. Accordingly, prayer is made to complete respond number 7. The Superintendent of Police Border, Baksa, has respond number 7. You have to file another application. The DC also has to be made a party. DC cannot be by Barpeta and then SP Baksa. DC Baksa who could next. Having heard the learned standing counsel for the FT and border matters in the matter, they indicate in this application, the prayer is allowed. The applicant is permitted to impede the Superintendent of Police Border, Baksa, as respond number 7. The applicant, the learned counsel for the applicant shall produce a special title of cost title and hand it over to the AOJ FT section for being incorporated in the petition and for updating the CIS data. Next paragraph. It is noted that the concerned district commissioner of Barpeta is arrayed as respond number 5 in the connected writ petition. So therefore, the applicant shall also have to make a separate application for implementing the jurisdictional district commissioner as a party respondent. Next para. Accordingly, the applicant is granted 10 days time from the date of the order to appear before the Superintendent of Police, Border, Baksa, and to take bail in terms of order dated 1/6/2026, passed in WBC 1481 of 2026. So in the event the applicant appears before the said authority within the extended time, the said authority shall act in accordance with directions contained in order dated 1/6/2026, passed in WBC 1481 of 2026. By treating the full stop, next para. This order shall be read together with order dated 1/6/2026, passed in WBC 1481 of 2026. And the reference to Superintendent of Police within bracket border, close Bofeta. It's contained in paragraph 9 of the said order shall be read as Superintendent of Police, Border, Baksa. This interlocutory application stands allowed and disposed of.
Time being item 35.
Well, the Lordship has directed us to take instruction on last order. Well, that instruction, short instruction I have received. Lordship has two queries. One is whether the advisory board is approved or not. But that advisory, the matter is pending before the advisory board. Hearing has been taken place. Final order has not come. And second query, my lord, his representation is under consideration. It is with the competent authority.
Then we take up the matter after the opening.
Lordship.
Please, my lords, may I kindly submit? My lord, my representation is dated 8/6/2026.
Whatever we already wanted that instruction.
Yes, sir.
What happened to that? We are not that query. So that will be considered only on the next day.
My lord, erroneously, it has been written as 7/6/22. That is why I filed an additional affidavit. Want to bring it to the notice?
It should be 8/6.
8/6, my lord.
Okay.
There's a typographical error. I apologize for it, my lord. Typographical. Same representation.
But an advisory board has to give its report within a time frame.
That's true. Not, what has happened here, no? Well,
Telephonic instructions to that effect.
no, I have the written instruction. Well, the order was issued on 17/10/25, but it was executed on 13/5/26. Executed lately. No? So on 13/5/26, it was executed. He was arrested, and the grounds of detention and the detention orders were handed over to him.
Okay.
Lordship may kindly take my instruction and kindly come to page number 2. He was identified on that particular day, Lord. Then these are the orders, Lord. The detention order and the grounds of arrest detention order at page number 3 and the grounds order is at page number 6. It was handed over, my lord, kindly see page number 10. He has put his signature at page number 11 on 13/5.
But Mr. P.R. Sharma and counsel for the petitioner also heard Mr. I. Bhattakul and CGC for respondent numbers 1 and 2, and Mr. D. Nath and the senior government advocate, along with Ms. R. B. Bora and a government advocate for respondent numbers 3 to 13.
Petition to 13.
Next, the learned counsel for the petitioner submitted that he has filed an affidavit to clarify that the representation referred before the respondent numbers 2, 5, 6, and 7 was dated 8/6/2026 and not 7/8/2026. So the explanation is accepted.
6, 7, 7, 6.
7, 6. Next paragraph. Pursuant to order dated 22/6/2026, the learned senior government advocate has submitted that he has received written instructions dated 13/5/2026, whereby it is stated that the detention order dated 17/10/2025 was served on the petitioner on
13/5/2026.
13/5/2023.
First para of the letter. First paragraph of the letter.
2026. As the petitioner could be, or could only be apprehended then. No, he was already in arrest.
This is my instruction, my lord.
No, he was under arrest.
My lord,
Detail-
was arrested on 12/5/26, then detained from 13/5/26.
Okay. He was served only on 13, or stop there only, 13/5/2026. To stop, it is submitted that on execution of the detention order, the copy of detention order, grounds of detention and documents relied upon were furnished. Next, it is also submitted that the said documents were read over and explained to the petitioner in Assamese language. And he was medically examined at FRU, Hojai. And thereafter forwarded to the superintendent, Special Jail Nagaon for detention under PIT NDPS Act. It is submitted that as per instructions received by him, the advisory board has already conducted the hearing and the matter is pending for orders by the said by the said learned board. By the advisory board. First off, it is, or next para, it is also submitted that the representation of the petitioner was forwarded to the competent authorities on,
But they filed on 18/6 and the representation was given on 18/6. It is before the competent authority for consideration. That is my telephonic instruction.
but the representation of dated 18/6/2026.
Check with the laptop, then it is, now it is yet to be competent authority.
But 8/6. Representation 8/6.
8/6 they have submitted, it was forwarded and
Okay.
the detailed timeline I don't have, but it is now before the competent authority.
Has been forwarded to the, for the competent authorities
Yes.
and and the disposal thereof is awaited. The information regarding disposal is awaited. Next para. This could by order dated 22/6/2026 had only sought for these preliminary instructions, making it clear that further considerations shall be taken up after the ensuing summer vacation. Next para accordingly. The respondents shall file their affidavit at least 2 days prior to the next date of listing. Next para. List for further consideration on (27/7/2026). At least 2 days prior, you
Malo,
file an affidavit.
lots of.
Instructions produced by the learned senior government advocate is returned to be produced on the next date of listing.
Lots of.
You-
I'll incorporate it in the affidavit. In the affidavit.
No, whatever be, but we're returning.
Full,
this-
full data.
It does, yeah.
Oblige my notes.
I'll have that.
Item 22.
Sitting here.
Item 22.
This matter pertains to custodial date of a son, your lordship.
So before submitting, my lord, I have some, we not make the party commissioner of police. In incident happen under non-monthly police station, even he not make the party OC also.
That's
Only
okay, the officer in charge will give you the instructions.
Lordship,
Officer is not the party. Oh,
we have filed,
Commissioner of police not party, it was for OC, non-monthly also not party. And the person died in before central jail, my lord, jailer, superintendent, jail also not party. So that's all.
Dr. Sharma, you will have difficulty in getting instructions.
lordship, we have filed an application before the district commissioner claiming compensation for the death of my son, your lordship, and that is pending. My limited prayer is, your lordship, that direction may be issued for speedy disposal of the same. That is my limited prayer. The representation is at page 37, your lordship. It starts from 37.
So we are not passing any opinion, let the authority decide it. But Dr. R. Sharma, the counsel for the petitioner. So heard. Mr. P. Sharma, an additional senior government advocate for the respondents.
On 1 and 3. Finance.
Okay, 1 and 3. Number 2 is finance. You are there. As well as 1 and 3, and Mr. A. Alia, standing counsel for the finance department, representing respondent number 2. Next. Speaking of objection has been raised by the additional senior government advocate that the concerned authorities of the police station and the other concerned police authorities have not been arrayed as respondents. Next one, the learned counsel for the petitioner has submitted that his limited prayer today would be to the effect that as the petitioner on account of death of her son, namely Arjun, ARJUN, Arjun Sharma, SHRMA, allegedly while in custody, he has submitted a representation before the district commissioner, Kamrup Metro, Gauhati, seeking compensation in reference to FIR number 114 dated 6/6/2025, which is registered as Numati PS case number 114/25 under section 87 of the BNS, 2023. Considering the nature of prayer made, being heard the learned additional senior government advocate and the learned standing counsel for the finance department, command the oral prayer made by the learned counsel. The petitioner is allowed by directing the district commissioner, Kamrup Metro, Gauhati, to dispose of the representation
Dated 27 October.
was submitted, dated 27/10/2025, submitted to the office of the district commissioner, Kamrup Metro, Gauhati on 27/10/2025, within bracket Annex K. Within a outer period of 2 months from the date of receipt of a certified copy of the order. Next, accordingly, the petitioner shall serve certified copy of the order along with a copy of the rest petition before the office of the superintendent of the district commissioner, Kamrup Metro, Gauhati, is to bring the order to the notice of the said authority. Next, in the meantime, the Learned senior government, additional senior government advocate shall also send a download copy of this order to the respondent number 3. Next part. Requisition steps allowed to the extent as indicated above, without entering into the, without examining the case on merit. We are giving 2 months time because, you know, on a death, if it is a custodial death, then you have to make an police, ministerial inquiry. So therefore, we are giving you time so that you can inform the authorities the reason of giving 2 months time. They have to conduct this inquiry and then do the needful.
Also, there are got some errors in my petition here also. The amounts shown in the
No,
application is
if you see, we are not examining anything. So whatever remains goes like that. If you have to do any corrections, then you have to bring, file an interlocutory application and have it corrected. Because we are not putting our own words, not even a single word we are putting it from our side. It's just saying that you send the petition along with a certified copy of the order. So whatever amount, if you want it corrected, then you'll have to file an interlocutory application, have it amended.
disposed of.
We are disposing of.
Yes.
Our orders, item 23.
Find two senior people, Mr. Monta is there, Mr. JP Sharma is there. Which items are yours?
Lordship, 23 is mine. My senior is on legs on court number 16.
No, there are seniors waiting.
Lordship,
Hearing
take it, take it.
23. Hearing item, item 33, mine.
33.
Yes. 33, 32 are, I know 33.
Yes.
32, 33, these are connected matters.
Connected matters.
Yes.
Mr. JP Sharma? Which is your matter?
Probably he's, there is no matter. Probably he's waiting for my matter.
Okay, okay.
So,
33.
23.
Four matters.
You made the prayer, which
Sir,
item?
I was in 24, your lordship.
Yeah,
For
that
that contempt matter.
Content matter.
But in 24, I have to pay for adjourning the matter now.
These are that series of contempt.
Yes, yes, Malak. Here I claim one of matter will be taken one of,
When are the other matters fixed?
lordship. I'm just indicating, no? Well, in the month of July, Malak, on 20, can it do 31st, Malak?
31st July.
31st.
The other matters are fixed then.
Other matters are, Malak. 31st. of July, Malak.
Fix the same day or? This item 24, you say both sides are represented. Mr. D. Nath, the counsel for respondent numbers 1 and 2 has submitted that similar the similar contempt matters have been fixed on 31/7/2026. So accordingly, this matter has notice been issued here.
Lordship, notice has been.
Okay, accordingly, list this matter on 31/7/2026. Item 24.
That's all it.
And 25 is not a connected contempt.
Not 30, I mean 34.
These are different. 25 and 26 are not.
Okay, yes, Mr. Mohanto?
My matter and the other matter. One, Mr. Right?
One is yours, one is Mr. Kane Chaudhary appearing.
30 to
Sorry?
34.
In one matter, Mr. Kane Chaudhary is appearing. In one matter, you are appearing.
No, in the other matter, BD Kumar is appearing.
Mr. Kumar and Mr.
Okay.
M.K. Chaudhary.
And the children will be different.
No, 30, 33, 34 is also connected.
No, your
No, acha, okay. Okay, so Mr. BDA Kumar is there.
Yeah.
Yes. Yes.
Now, the matter is not very big, but because the London Tribunal has just tossed out the facts, but an observation made which affects me. That's my case. And his case is, other side case is, that since he has come to that conclusion, the petition ought to have been allowed. So one appeal by the petitioner, the other by the respondent, myself. That is the case.
Yes, you are ready to do it today or some other day?
Other side is not here, but then I am interested because if it takes up, I can argue. Otherwise, lots of it fix it immediately after vacation.
Yes, you are ready to do it.
Lordship, my senior is ready in this, because Lordship, in this case, your Lordship has heard earlier in another division bench matter. So there was, thereafter it was released also. Lordship, we are ready in this case. If my senior is
Okay. Yes, then you can begin.
Yeah.
Lordship, my senior may begin with the appeal filed by them. In that case, my senior may begin with the appeal filed by them, item number 33.
My appeal is number 169, 33.
And where's Mr. M.K. Chaudhary?
It is the item number, Lordship, they have a separate matter, Lordship, the item number 30 and 34. This 30 was preferred by the government, Lordship. And 31, there is,
It is on the same matter.
all is the same, Lordship, the issue is different, Lordship. It is from different department, Lordship, and these two is different department, Lordship. So this may be taken several, Lordship. 30 and 31.
Lordship, this 31, 32, and 33, 34, the matters are different, but since since we have mentioned it together, it has come together. But the matters are different, 31, 32 and 33.
They are not connected in any
Not
way.
31, 32 is separate, 33, 34 is
Yeah.
separate.
Both these two maybe taken up several, they also should have.
31, 32 may be taken.
There is no tagging order.
No, actually, how it's taken, I don't know.
So it was mentioned before the Chief Justice, and it was, and both the matters were mentioned together. So it has been tagged out.
But this document is not there. Maybe taken up letter also, now my plan is ready for about 31, 33. Let them change that lawsuit. And
I'm not getting you. Please repeat again.
item 30 and 31, lawsuit. 30 is filed by the government lawsuit. And this is.
No, this is not
31.
30 and 31. This is, now we are taking up, Mr. Mahanta is making submissions on
33.
32,
32,
33.
Yes, lawsuit.
32 and 33 are connected matters.
Arising out of the
there
same
are
judgment.
judgment.
Arising out of the same judgment.
33 will detag it. We'll separate it.
This matter, your lordship has earlier heard it, but on the last occasion, since my learned friend has short time, your lordship has released it from Pata. The other matter was listed before the Honorable Chief Justice and Justice Omdip Chaudhary, because Justice Chaudhary could not take up the matter, so it has been transferred to this bench. And both these matters are old matters, my lord, which originally started in the year 2001. And now we are in 2026. For 25 to 26 years, still this matter could not be given a final quietus, my lord.
If you continue that submission, after some time, we'll have to release it again. So
So,
either we
my lord,
start
I
it or
think
we-
your lordship will, this will,
So they are
That's it.
trying to, because this matter has been lingered because of the twist.
No,
made
no,
by
you
them.
see, we have
No.
permitted
No,
you to
sir,
begin. You
with
can
utmost
just start
respect.
beginning, because at 4 o'clock I have to rise.
yes, ma'am.
At 4 o'clock I have to rise. There's a, what do you call, I have to attend a, training class.
If a lordship wants to dispose it of in one go, then probably we'll have to fix it some other day. Because two appeals, both sides arguments might take some.
Because after that, whether the bench will be here or not, we don't know.
Yes.
There's uncertainty of us being together.
But your lordship will direct the registry to list it on 14th of July, immediately after reopening. If the bench is available, they will, or
No, 14th, we have many matters.
14th may not be or immediately on.
16th, my lord.
16th,
Thursday.
let the court martial take a call.
April, no?
16th,
July.
16th is possible.
Yes, ma'am, Thursday.
Ah, you matter of. Yes, online. More than not 16th should also clear the things, huh?
All sides, including
Yes.
Mr. B.D. Kumar, and Senior Counsel in WA 159 of 2024, and Mr. K.K. Mohanto, Learned Senior Counsel in WA 169 of 2024 are present. Both sides. Pray for a early hearing of the matter. Accordingly, as agreed to by both sides, place the matter on 16/7/2026.
Yeah, other methods can be segregated, madam. These are not.
We will do it.
Yeah.
These matters, no, it is submitted at the bar that these two matters are not related.
No, my lord, there is one relationship. It belongs to the same college. That's why this matter has been tagged with by the, in terms of the order of the Honorable Chief Justice, because it relates to the same college. Same, it's a dispute between the same college teachers of that institution.
We'll have to hear it together.
Yes, yes. They are all connected issues, my lord. This is a seniority dispute, my lord.
No, but Mr. Mohanto is denying that.
No,
Even
no, my lord,
here,
my lord, there's an order from the Honorable Chief Justice to get this matter listed. It may be individual different orders, but it has both the matters is to
No,
be
no, you
heard.
see, here the short issue
Yes,
is with regard to the fact that this is a venture college
yes.
and
No, it's no longer a venture college. Now it's a
no, it's okay,
professional.
but originally when it started, the litigation history is that
Hmm.
you projected it to be it started as a venture college under
Yes.
the High College governing body. And thereafter, there was a judgment directing proposition of the service of Noor Muhammad, Noor Shahid.
No, my lord, there's a prior history to it. When initially in the year 2021, the one Muhammad Lokman Ali was appointed as the in-charge principal. And that was challenged before this honorable court. There was a status quo order operating not to allow him to function as a principal. In the meantime, in the year 2002, my lord, Borkhetri College had two colleges. One was the junior college and one was the degree college. Then, my lord, this Muhammad Noor Sahed and another professor, Noor Sahed is a professor of Arabic, Mamuni Bhachaji was a professor of SMS. Both the teachers' services were terminated, saying that the Borkhetri, they were the teachers of the Borkhetri Junior College and not the degree college. Then, my lord, in 2005, the matter was heard by the, at that time, Honorable Justice Amitabh Roy. There's a judgment, detailed judgment. The matter was relegated to the Director of Higher Education, and the Director of Higher Education was allowed to conduct an inquiry. And after the inquiry, it was found that both Nusaid and Mamuni Bhattaji are the professors of the degree college. Then when they did not comply with the order of the Director of Higher Education, we filed a contempt petition before this honorable court. In the contempt petition, my lord, they said that we have complied with the orders of the honorable court. What they did, they said that we will not give you seniority from 2001 or from your date of initial appointment. We will give you the date on 2007 when the matter was listed before the contempt court. Then at that time, my lord, the revenue minister, then Dr. Bhuida Marban, was asked to personally present before this honorable court in the contempt matter. Then after intervention in the contempt matter, all these two petitioners were given appointment from 2001. Now, what has happened after that, my lord, there was another petition filed by the some persons that there is interstate seniority dispute between the teachers of the Borkhetri College. So far, I am concerned, my lord, I am a senior Arabic teacher of the department. So far, my friend's client is concerned. She is my student. Now, her services has been regularized and my services has not been regularized being the teacher. Then when the interstate seniority seniority dispute came before this honorable court, the honorable court asked the Director of Higher Education to conduct an inquiry. In the inquiry, what they tried to do initially was that they tried to treat her, who was appointed much later in 2007, as senior to me. That was put under challenge before this honorable court, that how can you give the student seniority and all. Then this matter was, they took time, lingered, and in the meantime, what has happened? They got her services provincialized, leaving her teacher. We challenged the provincialized order before this honorable court. Well, a series of litigation from there. When this matter first came, my daughter was 5 years old. Today she has become a doctor, but still I can't resolve this matter of this petitioner who has retired. Now, only so far Nusaid Ali is concerned, he will get only the notional financial benefit, which is due as from the date of his provincialization, because I cannot take her service, because that legality of her service, your lordship can determine in this proceeding. So far, the other person is concerned, my lord, Azad, Mohammad Azad. Mohammad Azad was appointed earlier Mohammad Azad was appointed earlier. The private respondent, he was appointed in 2002. I was appointed in 2000 in a different department. So what they did, they manipulated his date of joining in that college and gave it as 2002 on the same day when I joined the college. Now, when they gave it the same day, then the problem arose that since he is senior in age, then that's why he should be given the benefit of seniority. So in a college, say for 3 persons can be provincialized. So he took the provincialization illegally by tampering with the record. This has come out. There was a CID inquiry. There's a forensic report, which all goes against them. And even the principal who gave the appointment allegedly to them has denied that I have not given him any appointment in 2002. That your lordship has earlier heard it. Now they are only delaying this matter so that they does not given a quietus from 2001, 2026. I have been unable to. So both these matters, why this has happened? I think
the simple question is that when Mr. Bonta and Mr. Hawk are saying that these are not connected, we are just wanting that how is it connected or not connected?
So far my connection is, I'll tell you, I am a teacher of Arabic of that college. Now, all these resolutions and all are same. The Director of Higher Education orders of provincialized, all the orders are same in more or less in all the cases. So each and every case I have to refer to the order. So if your lordship can pass separate judgment for both the cases, only the date of joining in will be different in Azad case and in my case that is. Otherwise, the documents relied in both the cases will be more or less same. Only in case of Azad, your lordship has to refer to those forensic reports. And the learned single judgment.
The question of tagging, untagging was there in the order.
Yes.
On order of 2023.
No, your lordship will look the last order of the Honorable Chief Justice, my lord. Well, because this matter was, I think, was dealt in the administrative side by the Honorable Chief Justice, because it was pointed out to him that it is the issue relating out of the same college. And the same faculty members. Your lordship may pass different orders, but both are old matters. It can be heard in the same day and different orders may be passed. Ma'am. So, say for example,
Look at this order, Mr.
Yes.
Order is of course dated 5/12/2023.
Well, let's see, madam,
There,
what
I think you have said that tagging is not required.
tagging is not required because,
No.
madam, they, he's better because factually it will be little bit different.
Lordship.
No, no, my friend should not have any object for hearing, for hearing the matter.
The question of hearing objection doesn't arise.
It has to be heard.
It should be hard together.
No, hard together means you make your submission in your own
No.
case, I'll make my submission in my own case.
Exactly.
Last portion of the order.
Yes,
No, Mr. Kumar.
yes, madam. Just a
Because
moment.
ultimately we will be
Yes,
bothered
very
by
right.
Yes,
the travel.
yes, that is the thing, my lord. That is what I want to avoid. Let the cases be listed and that may be heard separately. I am not on that.
Yes. No, no,
Question is-
I'm also not that, let
It
both
is
this
not a
matter come up
tagged
on
matter,
the,
so that
on,
can be
on.
decided in one go.
July 16th. Well, let both these matters be listed on the July
If you
date.
get listed and
Ah.
heard, I have no
Oh, yes,
objection. It is
for them, yes, yes.
to take care of.
Well, both parties have at least reached a consensus that this matter, subject to the convenience of this honorable court, will be listed on July 16th. My sir will make his submission on his case. My predicament is that I have to give two separate replies to.
Then I am more to my.
So I have to give my reply twice, the same reply. Well, the other division bench cannot take up this matter, madam.
Just a moment.
Only business. Asil madam. Governing body can. Then you yalla petition or last. I just will not approve. Voting case.
Getting them of course.
First, my lord, let this matter remain in the list. After that, my lord, after that, my lord, your lordship may, the one matter may take up the whole day. Then your lordship will again release the second matter on another day. But if it is off listed, my lord, it will be very difficult for us. My lord, we have been, this was listed in the list for so many months, but we could not get a hearing, my lord. It would listen. The main villain is that former principal. my lord.
There are about 20 more cases together, tagged together. What happened to all those cases?
No, those were initially different cases. So, those are different. So that's why that order probably, I have not read your lordship's entire order. Initially, it came in a group in a different issues. Madam. Then we got it unpacked from that group.
Okay. This, this order which we have passed will be this orders will be in item 32 and 33. Common order. 32 and 33. In 30 and 31. Both sides are represented.
Item 31, I am for the respondent number 1 in item.
Both sides are represented. Is agreed to by both sides. List the matter on, make it same day, 16/7/2026. Okay. This order will be in item 30 and 31. We are listing it separately, we'll hear it separately.
On this, but on the same day, madam.
Otherwise, it will be clumsy for.
No. I will make it convenient for the court. If necessary, we'll come up with a
No,
proper
your
list of dates.
Government itself was, it took us 25 minutes.
Yes, madam. My lord, this has got a checkered history. This is one
No,
of those
but-
cases, my
But
lord.
when adjournment takes 25 minutes,
My lord, your lordship will know. This is one of those cases from the day when I joined, is the first time when a cabinet minister of Assam was given personal appearance. That much of political interference was there.
that's okay.
Whether the
If
older.
it is 25 minutes, then we have to make our plan very clear.
Yes.
Yes, sir.
And on the next date, both sides will give us a list of dates.
Yes,
on
yes.
which
Very precise point, so far I am concerned, Lord, you will find
it's
it
not
very
an
precise.
argumentative, not an argumentative list of dates,
Yes.
the list of dates with bullet points.
We'll do it, madam. We have now the vacation, we'll enjoy the vacation. Sufficient time, madam, to prepare.
Why not?
Yes, sir. This time I am here, so no problem. We are blessed, sir.
All right. Very good. Yeah. All right. Hello?
Mr. Sharma, speaking after a long time.
But
This is JP Sharma.
yes, yes, he's on fire. Well, he told me that he'll be watching this. He's here. What an incredible room.
Mr. Sharma, speaking after a long time.
After a long time.
My lord, I've been to Bangalore, Gauhati. My sons are at Bangalore. So, you know, very few occasions now, my lord.
We call it.
But I hope.
No, when it comes to the, what you call silver screen, we say guest appearances.
Now it is time, Malad, regularly, it is difficult. So far he is concerned, for health issues, he won for his son, he used to get treatments. And again, for teeth, then again for eyes, and again for ears. That's how he was making 12 Pro. He informed me.
Age itself is a problem. We have to keep with the pace with the our age.
Don't worry, we will also catch up.
Yes.
And there is always, everybody.
All right. Lordship, all these matters will be taken on 16/7. Highly obliged.
For orders, item 23.
May it please your ladyship, your lordship. Your lordship, the last material order was passed on the 27th of May 2026, wherein we were directed to take fresh steps upon the respondent number 5 and respondent number 6. We had done so on the 29th and summons were delivered on the 5th of June. Lordship. Lordship, the matter is ripe for hearing. Services not completed. It was delivered. Delivered, but services they are not here. They're not.
SI Mintu Boyster and SI.
Yeah.
There.
By tracking the consignment report, they found that the
Yes.
services complete.
Yes, Lordship.
Otherwise, AD card has not.
Not before. Lordship, we do not know when the officers would be transferred. This is the second time the summons were issued. We have taken steps. 4 and 5. 4 and 5. 4 is the officer in charge of the Fatati Lambari police station. And 5 is the second OC lady.
Five, second officer.
Yes, what is your instructions, Mr. Sharma?
So, we have filed affidavit here. Affidavit filed by the post officer in charge of Khatasula Ambari police station.
Yes.
We filed.
So you can appear both, for both 5 and 6?
Yes, Lady Shri, there's no difference.
It's in official capacity.
Yes, Lady Shri.
The by name party, by name I don't know.
So
There
you
is some
can-
difficulty.
The entire transaction is the same, Lady Shri. Yeah.
In by name, generally, they engage another advocate. By name, we are right. If only officers, then I would be there. Now, my lord Mintu Boisha and SI Moody. By name.
They are not material, Your Lady Shri, if I
No,
may
no, six,
interject. They are not material
Chapter-
to finally decide this matter.
They will appear. They are counsel.
My lord may appreciate that the judgment in this matter may have a far-reaching implication, especially on the powers of the police to detain somebody indiscriminately without even an FIR under what provision of law, ladyship? What provision of law, my lord? I ask myself.
For affidavit, my lord, there was there are 4, is 14.
My lords, my submission here is, I pray before the court to kindly declare my detention as illegal. My lords, the admitted facts are these. On the 1st of November at 11:30 p.m.,
because I was picked up from my residence and they have admitted that I was. Why? No, Lordship, that is not, there is no FIR. If that was the case, there is no FIR. My case was that he was just picked. Lordship, Lordship, no, there is no FIR, Lordship. There is no FIR. The FIR that he alludes to, the officer in charge, is actually in a separate matter, my lords. It is FIR number 140 of 2025. No, my lords, it is entirely frivolous, my lords, on the basis of an FIR, my lords. My lords may have just a moment, my lords. My lords may have the first PR bond at page number 18. My lords, that is not the case at all, as has been set up by this by the police officers. My lords, the actual case is that I was picked up because of the fact that there is a vendetta, there is a divorce case filed against the brother of the petitioner by the wife of the brother of the petitioner. Your lordships, just to do an arm twisting, he was detained. They are saying there is no arrest, but the Honorable Supreme Court has stated that arrest and custody is the same thing. Lordship, the implication would be, the implication of dismissal would be tomorrow the police can pick me up. My lords, the entire year I was not picked up. That it is a matter of coincidence that the PR bonds were submitted on the 12th, 2nd and 3rd consecutively, my lords. Till date I have not been picked up. And the FIR that is alluded to, my lords, the FIR that is alluded to, it has reached trial, my lords. And I have not been arraigned as an accused person. There is no FIR, my lords. This made a mockery of the magisterial courts. My lords, may kindly appreciate, the facts are separate, my lords may kindly appreciate that every person, no, my lords, even if he commits murder, my lords, even if I commit murder, I have a remedy under law. The police here is making a mockery of the magisterial courts, my lords. My lords, the FIR is not there. Under what provision of law was I picked up, my lords? There is no arrest, there's no grounds of arrest, my lords. My lords, far-reaching implications. My lords may have it on a different date. No, my lords. No, that is incorrect, my lords. There was no FIR registered at all, my lords. At all. No FIR registered at all.
GD entry was there.
GD entry was there. My lords may have page number 18. Page number 18 and 19. They have submitted the GD entries. My lords, we just look at the top. Just the top for a moment, my lords. Just on the top, it says GD entry number 27. The next PR bond says GD entry number 27. More than 24 hours, my lords. It's on the same PR bond. No, lordship, but not the wife of the petitioner, my lords. The wife of the brother of the petitioner. Yes, my lords. Twisted the facts, my lords.
There is no such evidence, Millard, of state, Millard, I don't know. No, I don't know. 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 Millard. Just one clarity on the order, Milot. Here in the affidavit, they say the wife, the children of the petitioners were captured by the CWC. is not the children of the petitioner, but children of the brother of the petitioner. And my lords may not, may kindly.
Family.
No, legislation specifically mentions that the children of the petitioner, children of the, no, my lords, that is not the case. And my lords may be pleased to not pass that blanket order of him being arrested again and again. There's due process, my lords. There's due process. The police could have, I would not have filed this. My lords. Billods, that is entirely up to the discretion and majesty of this honorable court, because I'm not in that aspect at all. My problem is that without an FIR being registered, my lords, I was kept in custody for more, upwards of 24 hours. That is a separate case, my lords. They live separately. Regularly. They live separately, my lords. They live separately in a separate place. My only calm was that due process was not allowed. Let him be picked up. If he has done anything wrong, let him be. Millers, therefore, ergo, Millers, I am simply.
There's 16 minor. It is also light on that in the Child Welfare Committee, Kamru Metro found the necessary rescues both minor children from his family, ensuring that not his brother, his own children.
The affidavit has been stated that this is my children. This is not my children, Millers. They're not my children. Nothing has happened against me. Well, due process was not followed in this matter. I was kept in detention or arrest for upwards of 24 hours, Millers, on the same PR bond. They executed the same PR bond. These are manufactured documents. These are my submissions, Millers. Therefore, Millers may very well dismiss the matter. Millers may not have a blanket order concerning his liberty, Millers. May not have a blanket order. Give the police such powers to arrest him willfully whenever they please. They will come after him, Millers. The police will come after him. I was personally there on the 2nd of November, Millers.
Regularly, yes, sir.
Millers, no evidence has been placed. Even the GD entries have not been placed. There's no FIR. What question of charge is there?
GD entry will be considered as an FIR.
Even if there's a GD, my submission is even if there's a GD entry, when more than 24 hours, they're making a mockery. Within 24 hours, Article 22 guarantees that I have to be produced before a magistrate within 24 hours. And here they have categorically stated that it was upwards of 24 hours. Yes, Lord. Lordship may not have that blanket order. My lord, I request again, may not have that blanket order, last second paragraph. He has behaved, my lord. He has been a teetotaler. This incident is completely different, my lords. Maybe I could not appreciate, maybe I could not articulate on what was being sought. Very well, my lord. My lords may not have that blanket order signed for him to be picked up willy-nilly by the police. At least that. Yes,
Follow the law.
Lordship is repeatedly doing such type of.
If there is any other issue, maybe picked up as per process of law. Blanket order giving his arrest powers to the police, lords, detaining him for upwards of 24 hours without food, without water. I had asked for CCTV cameras footage also, lords. My lord. My lord. I'm obliged. Hmm.
25.
25.
Item 34 for hearing.
That please, your lordship. Yes, my lord, Lordship, kindly peruse order dated 28/4/26.
28-4.
Yes.
Number one.
Read petitioner respondent number one. And lordship may also kindly peruse.
This one.
Yes, he was a writ petitioner and he is respondent number one in the writ appeal. Even 17/3/26. Matter, my lord, pertains to
He does not want to pursue the case itself.
yes. My lord, there was a seniority dispute between this writ appellant and the respondent number one, so as to hold the in charge of Bojali Higher Secondary School headmaster. Now, my lord, the department decided in my favor, which was salient in the writ petition. And the learned single judge, by holding that the order was passed on a Sunday and records were not considered, allowed the writ petition. That's why we are before this honorable court in appeal, and the learned single judge order was stayed on 24/5/2023. Thereafter, the respondent number one, as per my instruction, he has been transferred to some other school where he is serving as the headmaster. That's why probably he is not interested to pursue this appeal. So, my humble prayer before your lordship would be, lordship may make the interim order absolute and close the appeal. Yes, they will fix up some other than that.
Yes, the matter.
Yes, yes.
Once this letter has been filed, it take note of that letter.
Yeah, earlier council has withdrawn my.
Yes, yes.
I'm not, as per your lordship convenience, lordship may fix a date. Close the matter. After hearing.
You put word in your mouth. There's a wrong appreciation of the matter when 17/3/2026 order was passed.
Minor.
I'll tell you why.
No.
You know about this letter?
No, man.
Letter was not what has been, is not what is in the order. What you said is there. He does not want to pursue.
But that was not reflected.
But this was reflected in the order is that brief was taken away. Brief was not taken away.
Which was not, he has requested for withdrawal of the.
Or withdrawal of the. We'll just put that in your mouth so that the order is corrected. None appears, sorry, Mr. J. Patwari, learned counsel for the appellant, has referred to copy of the letter dated 16/3/2026, which is available in the record. And it is submitted that the respondent number 1 had given a letter to to his learned counsel appearing in the matter of withdrawal of wakalatnama as he was no longer interested to pursue the case. Full stop. Next, we take note of the said letter dated 16/3/2026. Next, this court by order dated 28/4/2026 permitted one more opportunity to the respondent number 1 to engage another counsel. So Howard, from the said letter dated 16/3/2026. This is a part of the court. The respondent number 1 had informed his earlier set of counsel that he was no longer interested to pursue the matter. Next, accordingly, the court is accordingly, the matter is called today, none appears for respondent number 1. So accordingly, the matter shall be heard. On the basis of materials available on the court, divorce representation by the respondent number 1. Next panel. This is the matter for hearing on making it 28th of July.
Yes, actually,
28/7/2026, because we have fixed here other matters on. Otherwise, what happens is that once we pass an order, therefore it is the duty of the court to issue notice. So we have put those words so that we need not take any steps. Yes.
Deeply aware.
3 and 4.
Hmm?
I pay for respondent 2, 3 and 4.
2, 3 and 4, please record
Ada.
as Miss
Ada.
J. Das.
Ada.
A. Das, then counsel for respondent 2, 3 and 4. He's present.
Deeply aware.
Just a moment, not on 28, there is a special bench on that.
Can be in the month of
30.
August. Please.
There's a special bench on that day.
Item 36.
Wait, this is a PIL pertaining to unnatural deaths in prisons. What has happened thereafter, the state has already finalized the compensation policy. Lordship may just have the order of 29/1/26.
29/1/26.
Yes, sir. That framework and the compensation policy has been notified. Only aspect was that certain individuals have been identified in the course of pleading. So only prayer we had made is perhaps those individuals at least could be considered within that framework, given that it was notified as prospectively. So on that, instructions have been called for from the state. Whether it could be made retrospective, at least to these individuals.
No, but I think this observation with regard to the those people who have been have already died. Yes, you see, this any notifications or orders by the government will be prospective. The policy which is in force till now, that 2015 and notification,
Yes.
that will cover.
Yes.
At best, you can say in that is specific cases, if there is a case of death, only on those cases we can examine case to case basis. But so far as government is concerned, you know the limitations of the
Yes,
court.
yes.
We cannot ask the government to frame a policy to be acted in a particular manner. So therefore, by a judicial order, we cannot say that this would be made retrospective from any date prior to the notification. We do not have that power.
So then perhaps one aspect could be that given they have been identified by the government's pleadings, even outside the policy, if their cases can be taken up.
On case to case basis,
On a case
people
to
will have to
case basis.
agitate.
Yes, only if that consideration is given, then it can be otherwise closed. Yes, sir. We have the liberty to approach the government.
But Mr.
Yeah.
Learned counsel for the petitioners also heard Mr.
I'm here.
And Andrea Leonard,
Lakshmi, I'm appearing on behalf of the health department.
Leonard studying also for the health and family welfare department. And Mr. P. Sharma, Leonard, additional senior government advocate on the other state respondents. Next one. The learned counsel for the petitioner has submitted that pursuant to order passed from time to time in this public interest litigation, the government of Assam has formulated a policy for payment of compensation to the victims, within bracket prisoners, those who have suffered unnatural death during the period of confinement in jails of the state. Full stop. Next, the learned counsel for the petitioners has referred to the order dated 29/1/2026, wherein the court had recorded the submissions made by the learned counsel for the petitioners where it stated that the policy is prospective in nature. And there was no reference with regard to the death of the prisoners, which have already been identified. First of all, having heard the learned counsel for both sides, the voters of the considered opinion that in view of the law well settled on the point, court by dint of judicial orders cannot direct a particular notification of the government to have a retrospective effect. Stop. That's how court has been informed that there is already earlier policy in force for compensation. Stop. Therefore, in the considered opinion of the court, if in any particular case the family members of the deceased prisoner, who had died during custody, seeks any enhanced compensation, they would have to move the court on case-to-case basis for the court to consider the pair on the judicial side. Therefore, as the state has come up with a policy for compensating the victims, for compensation to the victims within bracket prisoners who had suffered unnatural death during the period of confinement in jails in the state. The purpose of this PI is served. However, it is left open for the individual for the family members of those individuals whose family members have suffered death during custody to independently move the court for a higher compensation from extra advised, and if such applications are filed, if such petitions are filed, or any of the applications are filed, the same shall be dealt within accordance with the law. Next one, importantly, there's nothing more surprising in this PL stance.
Deeply opposed.
That's possible. Can Mr. P. Gogoi name be recorded instead of mine? Since Lordship has already disposed of the PI, can his name be recorded?
Instead of him, refer to Mr. P. Gogoi.
No.
But this is a good issue taken up in the PIL. Now, how much is the compensation?
Lordship, so now the new notification has made a factual verification exercise which has been incorporated, which was not there in the previous one, where the secretary of the Home and Political Department is made the final authority after doing a complete fact check from the district level and the jail level to decide that compensation. That number, Lordship, that table has not been enumerated, I think, the notification. There is no, there is a table between 2 to 3 lakhs, Lordship, between 2 to 4 lakhs for different reasons. For example, death due to quarrel among prisoners is 2 lakhs, while death due to negligence by medical officers is 4 lakhs. So there is a graded list. That is pertaining to, I think, victim compensation. 2015.
That is 2015 notification. But I don't think there's change in that. You see, this was the earlier one. Oh, this is 2024.
This is 2024. The
Okay,
latest
so
one is of
same thing,
2024.
Okay, same thing.
27/12/24.
Central, okay, we have that.
That is the latest one.
Okay,
That is in versions of this PI.
okay, we have that. But, I think after this, notification, so far as our knowledge goes, there is no litigation at all with regard to,
Yes.
no, sorry, there may not be any case of any person suffering a death because most of the criminal reputations are already before us.
Yes.
There is 2 or 3 which recently came to our court. Only 2 or 3. There's not much. Because wherever there has been death, people are filing their reputations, so I don't think there are much people after that. Okay. So, but we appreciate the issue taken up.
Now, death by negligence is also included within unnatural death due to negligence of the jail officers or.
Yes, that has been included. Yes.